Ladies and gentlemen, welcome aboard the Pilot Lawyer Podcast. Thank you for your attention while this important legal information is reviewed. What you hear should not replace consultation with an attorney and should not be considered advice for your situation. On behalf of the Pilot Lawyer and your entire crew, it's our pleasure to have you aboard.
Welcome, aviators, to the Pilot Lawyer Podcast. With us, the Eisen brothers at the Eisen Law Firm, where aviation law is all we do, nothing else. You're here for what we do best, navigating the FAA medical certification process for pilots and those who want to become pilots. And of course, if you don't laugh, you cry. And for the next 30 minutes, we hope to bring you the lighter side of what can otherwise be a frustrating process. So whether you're laughing at us or with us, join us brothers as we discuss the fascinating world of FAA medical certification. Now, I'm beginning to wonder why we haven't pre-recorded the opening, because it's taken us about 45 minutes to get that little sliver right there.
That's an excellent question. Perhaps we should.
Well, here's the thing. Who we got here today? Let's get that part out of the way.
It's the usual people that you've known, loved,
and loathe.
What is it? You've grown. You've grown to know and love.
That's correct.
Yes.
Christopher, Alex, Anthony. Great. So here's,
et cetera.
So here's the thing. What are we talking about here today?
I think we should
I'm going to get straight into the content today.
Content it.
Talking about FAA medical certification and VA disability benefits, specifically where we at now with this crazy witch hunt that they've got going on with respect to individuals who haven't appropriately reported their VA disability benefits on their applications for airman medical certification. Let me give you a little bit of a primer, if you will, primer, however you want to pronounce it, on where we've been with this issue previously, starting from the beginning of time. So God created man. Okay. So anyhow, in our practice at least, we've seen this issue with VA disability benefits and airmen not having reported their VA disability benefits on their medical application for many years. This isn't a new issue. It started off preliminarily with something called Operation Safe Pilot, where the Department of Transportation's Office of Inspector General identified individuals who needed to report their VA disability benefits who hadn't. This resulted in some individuals losing their airman certificates for falsification, as well as for criminal liability under U.S. statutes. It was a very intermittent thing for many years. You'd maybe see one or two individuals pop up with not having reported their disability benefits. Then in about May of last year, we started to see letters come out where there was deemed a special project, where apparently there had been the Department of Transportation's Office of Inspector General had essentially generated a database between those individuals receiving VA disability benefits and who had not reported said benefits on their applications for medical certification at question 18Y. Primarily, individuals were getting letters of investigation in the mail. And as things had been handled prior to that point in time, there was cause for concern, maybe still is cause for concern, with respect to potential enforcement action against individuals who had received a letter of investigation. However, it would seem, this is just us hypothesizing, that there were more individuals caught up in this sort of sting, if you will, I don't want to call it a sting, but this operation than was originally anticipated. And as a result, instead of pursuing enforcement action and letters of investigation against every airman, the FAA then transitioned to issuing letters of correction for certain individuals. This is an issue that we've written about extensively for AOPA on our own blogs, and we've helped numerous airmen through this process since the special project was initiated back in 2022. That being said, there was a large push when airmen were getting letters of correction and other airmen were still getting letters of investigation, and there was a mismatch between the type of sanction that would occur and outcome that would occur for airmen who were similarly situated. AOPA got involved, and they said, hey, wait a second, this isn't right. I would say maybe piggybacking on some of the articles we wrote for them, and they pushed for amnesty with the FAA for these airmen receiving VA disability benefits. Now, we're seeing what we're calling reconciliation letters. A reconciliation letter appears to be some form of amnesty, wherein the FAA is allowing airmen to go and apply for a new medical certificate by a certain date, wherein they will identify in its complete form their VA disability benefits on their medical application. But what's not being identified is primarily these individuals that are taking advantage of this opportunity and applying for a new medical certificate by the date provided by the FAA, are getting deferred by their AMEs or the aviation medical examiner at the time of exam. There appears to be a flag on a lot of these files where even if the AME wanted to issue the certificate, they're getting deferred. Now, I wouldn't say that that's a blanket rule. We are seeing cases that don't have flags on it. But it is good to be aware of the fact that there have been flags on these files. That pretty much sums things up on where we're at right now. So now that I've done all the talking, let us please have a discussion.
So what would your recommendation be to people who have not received the letter nor filed an amendment?
That's a very coherent, well thought out, and logical question.
Overruled.
So here's the deal. If you haven't received a letter of reconciliation where the FAA says, hey, thanks for your service to our country, and so on and so forth, we need you to go submit a new medical application, there is sort of the suggestion that you should run down to your AME and submit a new medical application because that'll fix everything. Well, not so fast, Sally.
Wrong-o.
Not so fast. Instead, what should you do, Christopher? Discuss.
Well, the first thing you need to do is call us to get one of those letters. But if you haven't got one of those letters, the first thing you should do is call us. Either way, call us.
When should you call us?
I'll tell you why. If you haven't received one of the letters, there's a lot of times I'll talk to people and they kind of have a misconception about this reconciliation letter. And they're kind of bummed out that they haven't received the letter yet. And they feel as though they're going to somehow miss out on this grand opportunity to fix this issue because they haven't reported their VA benefits and the underlying medical conditions to the FAA. And so now they're thinking, oh, well, the FAA didn't send me the letter, so what's going to happen? Am I in the wrong? To the contrary, I think it's because you're not in the regulatory crosshairs. The FAA doesn't have you on their radar, and you're actually in a better position in some respects than people that have received these reconciliation letters because now you ostensibly have the high ground to do a proactive amendment to bring it to the FAA's attention that you need to correct those incorrect statements on the 8500 application to reflect the history of VA disability benefits at 18Y and whatever the other underlying medical conditions are that you receive the benefits for at the other appropriate items in Section 18. And so if you haven't received one of the letters, but you do need to bring this to the FAA's attention, we need to do an amendment ASAP. Don't let any grass grow under your feet. We need to get that in as quickly as possible. And here we do this on a daily basis, wouldn't you say?
Yes.
There you have it. He said we do it on a daily basis.
I don't know what more you need.
Yeah. So obviously when you do as many of these as we do, we understand kind of the form, if you will, the format to submit to the FAA, who to submit it to, how to get it to them so that it can get into your airman medical file as quickly as possible. Some of the key language that you want to have in there in order to effectuate that document as an amendment to the past application. So there's a bunch of nuance with respect to that process in and of itself.
A bunch of nuance. It's not just one piece of nuance. It's a bunch of it. Now, let me tell you this much. What's going to catch you off guard is when you go in and submit your medical application, you get deferred. What's going to happen then?
Well, at that point, you're going to go in there and you're going to say, okay, here is what you should do on the application is you should take your VA award rating decision letter and you should take everything that's listed on there, whether it's rated at 100% all the way down to the items that were found to not be service connected.
Wait, so I should put things that I'm not service connected on, even though I applied for it, was denied? I don't mean to talk like a air show announcer, but coming on down the runway here is a good question.
Yeah, I would say in most cases, there have been a couple of cases where I've seen where we've kind of said, well, maybe not on that particular issue. But by and large, if you have a medical condition that was found to not be service connected, that medical condition should probably also translate over to the 8500 application because the question there is, have you ever in your life? So it has a very broad look back. It's not like, have you ever in the last 5, 10, 15 years? Just no. From the time of inception to present, have you ever been either diagnosed with, previously had, or presently have? So there's 3 different types of ways that they're looking at whether or not you've had, and then all the questions in Section 18. Keep in mind that 18X is a very broad catch-all within a very broad question, and that 18X asks other illness, disability, or surgery. So if 18A through whatever is up to X, I'm not very good with the alphabet, isn't one of the questions that would capture one of those medical conditions that you're receiving a benefit for or have applied for a benefit for and been denied, then that 18X is likely going to capture it as well. And so you need to put even the ones that you've been denied on as not being service connected on the application. Because if you felt that you had that illness, that condition, such that you were willing to apply for a benefit for it, that it needs to translate itself over to the application, in our opinion.
So the idea is that if you've applied for the benefit from the VA to the VA, you're telling the VA, hey, I think I have this such that you should compensate me for it.
Yeah. And if that's the case, then you should probably be telling the FAA about this condition as well. And one in particular are those individuals that have a history of PTSD, for example, where they've applied for whatever reason, right? And then the VA, for whatever reason, didn't determine that they had a service-connected disability with respect to PTSD. So does that mean that they don't have PTSD at all, or does that mean that it just isn't service-connected? Well, obviously, the individual thought they had PTSD, otherwise they wouldn't be applying for a benefit for it. And I know that's somewhat of a kind of a touchy subject because there's services out there that go through your records and then they'll just kind of apply for everything under the sun, I think, based on what's in the record. And that's a whole issue in and of itself. But if you've had that, regardless of whether you had someone help you or not, if your name is on a piece of paper saying, hey, I think I have PTSD, and the VA comes back and says, nah, we don't think it's service-connected, well, that doesn't absolve you of telling the FAA about it. You still need to tell the FAA under 18M because of the way that question is worded. Have you ever in your life had, have, or been diagnosed with?
Has your FAA medical certificate been denied? Are you concerned you may not be able to get a medical certificate from the FAA? Are you at risk for FAA action for failing to report your medical history appropriately? Call the pilot lawyer at 1-855-FAA-1215 to discuss your options for getting the FAA to issue your medical certificate and get you flying. We are happy to evaluate your case and discuss with you a plan for presenting your case to the AME or the FAA. Aviation law is all we do, nothing else.
Well, let me ask you this question. If I get this reconciliation letter and I go in and apply for my application with the AME, put all this down, right? I'm airing it all out, baby. And I'm showing it right there. I'm putting it right in their face.
You do that out the caps here so quick.
Don't you think the cops are going to come out and grab me at the AME's office? Am I liable? Have I been set up?
So in this situation, I mean, it's kind of a brave new world in some respects where the FAA is saying, hey, go submit a new application and make sure you tell us all about this. I mean, in a lot of respect, I would say if you have the government coming to you without knowing of a need for you to actually do this in the first place, because we've seen some cases where the individual has previously reported the history of receipt of VA benefits on their applications and the underlying medical conditions. And they're like, well, why am I getting this letter? And so that, I think, is maybe just a telltale sign that the FAA is just blasting out these letters to anybody that they see that has benefits, not really looking at the airman medical file. But for those that haven't, does the FAA know that you need to do it, or are they just, saying, oh, well, he's got VA benefits, just send him the letter anyhow? Regardless, if the government comes to you asking for you to take some action without having some articulable basis to know that you need to do it, what I'm getting at here is that, how is this not like equivalent to entrapment in a criminal defense case, right? So they come to me asking me to do something and I have no obligation to do it. Does that make sense?
I understand what you're saying.
Be that as it may, when you get there to your AME, there's likely going to be a flag on your file, right? And so if you take advantage of the reconciliation process that the FAA is offering you in these letters, when you get to the AME and you've now got your application all right and tight, accurately reflecting the history of your medical conditions, the receipt of the VA benefits, et cetera, and your AME says, all right, you know, maybe you don't have anything that's immediately a red flag or looks to be disqualifying, or the AME believes based on the guidelines he could issue a medical certificate after his evaluation. There may still be a flag on your file that the AME couldn't get past, and he's going to have to defer your application to Oklahoma City for further review, which then begets a new question. Is it really Oklahoma City that's looking at these applications?
Well, I'm no soothsayer for each person's application and situation.
What's that about your truth?
I'm no soothsayer, but I can tell you based off of previous cases, kind of backing up a little bit, the individuals who've received this letter and gone in for their medical applications have not experienced any type of enforcement action. It appears to be playing out as some level of amnesty. Now, I guess theory that could change for individuals with severe aeromedically significant conditions, but certainly we've not experienced that at all. So it goes along with your theory. Alex, I want to introduce a new segment to the show.
What is that, Anthony?
We're going to call this segment the In-Flight Entertainment. We're going to let Alex start today.
So we got a little brain tickler, if you will. So, Christopher,
Let's tickle your brain.
you ready?
I
You
was
tickled.
More like
Well,
a jostling for you.
I was just picking my nose. I was pretty tickled.
Alrighty. So imagine
Okay.
a plane you're flying on is crashing.
Okay.
If you can't stop the plane, fly the plane, jump out of it, or save the aircraft in any way, what will it take to save yourself?
Wait, hang on a second. The plane is crashing. I'm not allowed to jump out of it. I'm not allowed to fly it.
Mm-hmm.
And I'm not allowed to do what else?
Anthony, I think he's coming right into the trap here.
Hang on. I'm just wondering.
Yeah. You can't fly it. You can't jump out of it. You can't save it. And
What can I do to save myself?
Just imagine.
Repent and give myself to the Lord God, our Jesus Christ and Savior, et cetera, et cetera.
You know the words.
Did I get it right?
No, he didn't.
Oh, well.
That's a good start,
That's about
though.
all. I mean,
That's a good
it's
start.
like-
We'll tell the answer the next podcast.
no,
Yeah.
let's just get to it now. What is it?
You stop imagining.
Well,
Ridiculous.
it's about the same, I guess.
You're going to die either way.
Yeah.
Let me say this much.
So that's a topic for another podcast about the cardiology. Cardiology.
Cartilaginous.
Cartilaginous. Let me say this much. All right, now that
Heart
we've had
stuff.
now that we've had fun. What's the deal? What happens once the FAA sends you a reconciliation letter? You waltz down to your AME's office. You submit a medical application. It gets deferred. What's going to happen then? Huh, smart guy? Huh, college?
I don't know. Something's going to happen and it's not going to be good.
No. You're going to get a letter from the FAA.
Doesn't sound good.
Well, and they're going to essentially say, hey, in light of your X, PTSD, obstructive sleep apnea, blah, 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 we require additional information. So whatever the specific question is that's relevant, they are going to specifically ask for information on that condition. So, but they may, beyond that, ask for all your medical records. Let's say, for example, PTSD is one of the disabilities that you receive benefits for. They're going to say, oh, send us all your treatment records. Send us your C&P exams. Send us, any records you have from the VA about this. Alex, do you have anything to say about the nuances of getting the VA records? Because that's about all you're good for down here.
Yep. The VA is probably just as difficult to deal with as the FAA is.
You're kidding.
No, I wouldn't
Nobody
lie
would
about
know
that.
that.
I wouldn't fit that.
Go ahead.
So requesting the C&P exam, you have to do
What's
that
C&P?
compensation and pension exam. It is, you have to request it through a FOIA
When do you have the compensation and pension exam?
right after you're discharged.
So that's essentially the exam that warrants you
Right.
getting the receipt of the benefits?
Correct. Yep.
Gotcha.
So we found that the majority of these exams are provided by like third-party physicians. Which
Can you
then-
get the records directly from them?
No, you can't because it's government property. Government. The federals.
Why can't the government just give it over to the FAA then?
Because I don't know.
That sounds like a legal question.
I don't know the
Yeah,
question.
I don't know the answer.
Well, I don't know the answer to that either. Do you know, Smarty?
Sure, but it's going to cost you.
This is already costing
I'll take it
me.
out of your share. Go ahead.
So you had to request the CMP exam through a FOIA request, and that it's such a hit or miss. I've had people who, they'll send over the exam results within a week on some people, and there's some people who we've requested at the end of last year and still waiting on it.
You sure you requested them correctly?
I am 100% sure because it's the same number I sent the other ones to.
There's a workaround on some of the VA treatment records, though. Is that right?
Yeah,
Tell me
so-
about that.
So on the My Health eVet website, there's something under the medical records tab called the Blue Button Report. I don't know how they came up with that. Whatever.
Probably a blue button.
Maybe.
going.
But basically all of your treatment records from the VA go into this report, and you can download that again on the My Health eVet website. And what was it? Houston VA requested records on a client, and 4 months later, and I was pounding on their desk, wanting them because technically they only have 30 days to respond to
Give me your
requests.
badge and your gun.
Give it to me. But yeah, it took about 4 months of calling every week.
Sir, I'm janitorial in nature.
I told you not to call me again.
All right, we've heard enough from Alex.
Yeah.
Moving back.
It's a very exciting life I live.
so monotone.
Anywho,
So what do we want to talk about now? What do you think?
talk about
what do you
anything
think?
else? That you had?
What do you think is going to happen next? So that being said,
you
let's
get
say-
your records.
Yeah, you get your record. Get your records. It's a painstakingly long process, and the FAA is only going to give you 60 days. So the important point here is that you should start getting your records well in advance of the FAA asking for anything. Because in doing so, you may be well ahead of the game, because if you wait and start gathering your records at the time the FAA asks for your records, you might be well outside the 60 days that they've allotted for you to gather your records, just because the VA is so frustrating in that capacity. That being said, you could always get an extension on the FAA's informational request, so keep that in mind as well. The folks that are handling these reconciliation letters, they tend to want more details of why you're asking for an extension than what we're typically seeing with Oklahoma City in a regular case, but you still ask for an extension.
So you've asked for the extension during that period of time. You've
Have you-
gathered the information that you needed as originally requested. You've provided it to the FAA. Now what?
Now you wait.
How long are we waiting?
Probably 2 to 6 months. Now, that being said, that's where somebody like the trusted counsel and caring, loving support of the Eisen Law Firm, or some other attorney, if you must.
They probably don't care as much.
Yeah, that's where
Is that
it becomes-
readily verifiable for the
I don't
bar?
know. So anyhow, that's where it might be important to have a service, such as ourselves or others, review your records and make sure that what you're putting out there into the ether is not going to cause further delay. For example, if I just blanket send out all my records to the FAA and I don't realize that on page 34 discusses some ancillary concern, alcohol use disorder, sleep apnea, whatever other condition Christopher probably has. In doing so, the question there becomes, well, once they review these records, now they're going to forget about the PTSD or not, to put that on the back burner. Now they're going to care about my alcohol use disorder or my left toe fungus,
So what you're saying is
which I've seen that before.
it's important to ensure that what you're sending them coincides or matches up with what's on your application.
Well, but at the same time, you're getting ahead of any concerns that they may have so that you don't wait 3 to 4 months for them to come back and say, well, give us information on this now. And that you could have gotten ahead of that so that you're not staggering requests.
Well, I think this is probably something for you to say, but I see the airport in sight. Do you have any final approach thoughts?
Well, my final approach thoughts are that if you haven't reported your VA disability benefits on your medical application, perhaps don't run out and submit a new medical application. Instead, the appropriate mechanism, in our opinion, would be to submit an amendment to the FAA. Furthermore, if you have received a letter of reconciliation.
Now that you say that, we got to do a go-around real quick. there's a goat on the runway and we got to go around. There have been several individuals I've spoken to over the last couple weeks that have kind of been confused about, well, I did a new application and I got deferred because I had the flat, but I already had time remaining on my last application.
We see that a lot.
And so I'm still good to fly, right? Because I still have time on my application. I mean, I've heard that once. I've heard it probably 100,000 times so far. And I think there's a concern there that maybe if you have a deferred application, despite maybe having another year and a half left on your current medical, that year and a half that you had left, that's gone, right?
Yeah, I mean, that's our perception, and that's been our experience. The FAA sort of, I think, could make an easy case to say, well, if you've submitted your medical application, it's been deferred, that suggests that we don't think you're eligible to hold a medical. Or even still, once you submit a medical application, it's our perception that that voids or eradicates the old application.
Is there a difference, though, between submitting an amendment versus submitting an application in terms of how that affects your current medical?
If you submit an amendment, you still hold your current medical certificate, so which doesn't eradicate or void your medical certificate. So you're better off time-wise by submitting an amendment with the knowledge that under 14 CFR 6153, you should self-ground if you know or have reason to know of a medical deficiency.
All right. Well, I see the airport and site.
Oh, we're bringing it back around.
They've cleared us to land.
Yeah,
we're already on final.
We've exhausted that
We're exhausted already. I'm tired of flapping my arms. Let's land this thing.
Yeah. Flapping your gums for sure. So that being said, I think there's that, and there's the piece about wanting to be prepared with your medical documentation and call us.
You could also be proactive and get this stuff to the FAA again through the amendment process, but then have everything kind of ready to go, so you can maximize or streamline the process to minimize your downtime.
Oh yeah,
Yeah, that's a whole other If you want to talk more about that, call us.
it's beautiful.
That's showmanship.
Well, you've gone and done it again and logged another uneventful half hour listening to the Pilot Lawyer Podcast. And even though, our wives deny they know us in public, even
Even after the success of this podcast?
yeah, it's not like they're like clamoring to be with us now because we might be
They've distanced themselves
even more
further.
so.
we might be recognized in public. No. I guess she loves me. I know you love me, dear. Again, we are the Eisen brothers at the Eisen Law Firm. We'll see you next time, if there is one.
Lord willing.
This is thepodcastfactory.com.